Lawyers argue that former Justice Minister Herbert Volney had no reason to lie about Section 34 to his then fellow members of Cabinet. That's the picture painted in the High Court today as attorneys for the accused in the Piarco corruption cases continued making the case that government was aware of the implication of Section 34 long before it was proclaimed.
The Attorney General's affidavit comes under scrutiny for a second day, as lawyers chisel away at his claim that the former Minister of Justice, Herbert Volney, misrepresented certain facts to the Cabinet. Also coming into focus, the DPP's affidavit, with lawyers contending that well before Section 34 was proclaimed, he knew it would affect the Piarco corruption cases. Queen's Counsel Michael Beloff picked up where his colleague Edward Fitzgerald left off yesterday. He represents the Maritime Life General Insurance Company, one of the companies charged in the Piarco case. The barrister said DPP Roger Gaspard's affidavit never mentions any promise from Minister Volney that there would be no early proclamation of Section 34. The QC also pointed out that whether Section 34 was proclaimed early or on schedule, the effect would have been the same, to make the Piarco accused eligible for a discharge. Using that logic, he told Justice Meredina Mora, quote, "A misrepresentation of the kind alleged would have had absolutely no purpose at all," end quote. He went on to say the AG's affidavit is, quote, "remarkably imprecise in providing any explanation of what this alleged misrepresentation was, rendering his claim, quote, entirely devoid of legal significance." QC Beloff also noted that the DPP never says he was unaware that Section 34 would quash the Piarco cases. In fact, the DPP's office wrote the Justice Minister last May advising him of this effect. The attorney told the judge, quote, "We have on the one hand an Attorney General who is unable to explain how he or anyone involved could ever have misunderstood, and on the other hand a DPP who doesn't claim to have misunderstood anything at all, and until September 2012 seemed quite content to hold his peace," end quote. The barrister pummeled the state for what he called an unjust motive behind the repeal of Section 34. He says that repeal legislation solely targeted his clients, all in a bid for the state to protect its prosecution in a high-profile case. In his affidavit, the AG says the repeal was the product of, quote, mature consideration. But QC Beloff contends it was a hasty move, triggered by public uproar. He says the AG and the DPP acknowledge in statements they made publicly and in writing to one another that a repeal was necessary specifically to avoid derailing the Piarco cases. Senior counsel Sophia Choate, who represents another claimant, Amir Idu, is expected to make her oral submissions tomorrow. Fane Richards, TV6 News.